Okay, I've already discussed that letter or the phone conversation my ex-wife had when we dealt with free speech. These are the transcripts or the court orders dealing with her and the father of her youngest child. This is what the judge wrote, Judge Seiss wrote. Of equal concern is disturbing tape recorded and exhibit evidence of the erotic behavior of respondents' rages of anger both toward petitioner, the father, and her mother. Although respondent portrayed herself as a caring and nurturing mother as she testified, evidence contradicting that portrait was presented during petitioner's case and on cross-examination of the respondent. Indeed, respondent's own mother related disturbing evidence of respondent's irresponsible behavior and opined that the subject child would be better placed with the father. Further, the tape recordings of respondent on the phone to petitioner reveals the rage and lack of control respondent exhibits towards petitioner. Respondent presents herself as a parent who should undergo a psychological evaluation and successfully complete any and all counseling or recommended classes. Then they go through. This court finds that the petitioner offers Jacqueline the ability to provide for his daughter a loving, caring, and more stable environment. That the child, then what do they order? This was the first time. The one I got wasn't allowed in at first. Right after they said the courtrooms were open. That the subject child is placed in the joint custody, legal custody of both petitioner and respondent. I'll tell you, if it had been reversed, he wouldn't have gotten joint custody, with the petitioner father having primary physical custody. Respondent shall enjoy the rights to custodial visitation the Monday of each week after the child finishes school day until the child commences the following morning. Wednesday of each week, and from Saturday on the weekend to Sunday. In addition, respondent is ordered to attend a psychological evaluation arranged by the Saratoga County Department of Social Service and attend successfully, complete all recommended counseling. He also ordered it of the father. The father went to it and the psychologist said, "What are you doing here?" and wrote a letter. He didn't even have to go back again for the second one. But because he ordered it for her, he felt he had to order it for him. $19.99, that was $98. New judge. This one's got a real interesting catch to it. Although the court generally favors joint custody, the same cannot be continued here as the mother has consistently placed her own interests above those of her daughter. Consequently, sole custody must be awarded to the father. He should have gotten sole custody the year before, but now he's getting, and visitation according to the mother pursuant to the following schedule. Now, here's the kicker. I have never seen a father get it. The court concludes that the father willfully violated the order of this court denying the mother custodial time with Jacqueline on May 29th, 30th, and 31st, 99. Now, she had done that several times to him. I didn't see my kids for 6 years. I never got up any makeup time. I never got anything. Here's what the court does. And I used to ask this for parents, in the petitions. The fathers get makeup time. They only have the kids 52 days a year. The father willfully, by denying the mother the custodial time. The mother is granted makeup visitation of 9 days. 3 times. She loses 3. She now gets 9 days of makeup time. Boy, are they punishing the father. To be exercised on weekends at choice of the mother upon 14 days advance written notice to the father. The same to be exercised within 180 days. Have you ever heard of such a thing? Then he writes, the court concludes that the father did not willfully violate the order of this court by denying the mother custodial time in Jacqueline in December of 98, and said petition is dismissed. You know, absolutely amazing. A mother gets makeup time. Fathers, as I said, in 20, 30 years I've been doing this, I've never seen it happen. 20 years or so. It was so bad that the mother appealed. The psychologist wrote a letter. He's got custody. At this time, I would recommend against a change in custody. Jacqueline has experienced a significant number of changes in life recently, including a change in school and a change in her mother's residence. I would also recommend that an alternate custody plan be discussed and implemented for the next school year, such that Jacqueline does not transition between the marital households during the week. In other words, she's saying the child should not be with the mother at any time during the week. As her economic work becomes increasingly more challenged, these transitions will become increasingly more disruptive. Knowing the mother, she's absolutely right. Jacqueline is more than capable child who presents herself as above average in intellectual functioning and social skills. While she has demonstrated consistent progress in mastering the challenges that her family situation has presented her, should be her mother has challenged her, it would be unfair to expect Jacqueline should accommodate to future disruptions in routine schools and family life. The mother used to change the child's school every year. Now, this is how bad some of the places are. She had her in Catholic schools and private schools and everything. And then the mother, when she changed schools, she would take the child back to see her old schoolmates at other schools, and so, which really confused the child. But what was funny was when the father got custody, he went around to the different schools to enroll his child in schools. He's got custody, primary custody. You know what they told him? We need to talk to the mother first to make sure. We have to talk to the mother about her coming here. He goes, why? When she brought the child in here and she went to school, you never asked to see me. This is how bad it is. In other words, they want the mothers controlling everything. And that's what she does. Even when he had primary custody, she's still trying to control the situation. Now, she ends up back in court again. This is in 2002, a year and a half later. She had the visitation schedule that they have. It's now been cut back. Ordered, shall have visitation with the child every Sunday from noon at 7 p.m., from noon until 7 p.m. She's given 7 hours. That's Sunday morning, Sunday noon, with the respondent to pick up the child at the commencement of visitation and return the child to petitioner's home at the conclusion. I have never seen a mother be responsible for transporting the child to and from the father's home until this one. That the party's child and the respondent's fiancé shall appear before Dr. David Horstein for a psychological evaluation, the cost of which shall be paid entirely by the respondent. That no unrelated male shall be in the presence of the child during her visitation with respondent. Now, why would a judge cut her visitation back to 7 hours, send her and her boyfriend for a psychological evaluation in order that no unrelated males can be present when she has her daughter during that 7 hours? I'll tell you what happened. The child started complaining to the father and everybody else that the boyfriend, or her fiancé as they say here, used to like to grab her behind the leg and then run his hand up and squeeze her little ass. How sick is that? The mother didn't care. She didn't care what was going on with the child. She said the child was lying. Thank goodness at least one judge listened. Well, it gets better. Well, the next year, the mother files another petition to get custody of the child back. And they go before Assini again. I'm not going to go into the allegations or anything, but I will say, if it had been me or the father doing it, one or both of us would have been in jail. That's all I'm going to say. You know, that endangering the welfare of a child. Now, during the trial, the father said they put the daughter on, she put her daughter on the stand. He told me that her attorney was absolutely brutal to that child while she was on the stand. He would ask the same question 4 different ways, but he still got the same answer. In fact, the father told me that the judge had to interrupt him many times and told him, "What don't you understand about her answer? You've asked it 4 or 5 different ways and she keeps giving the same answer. What don't you understand about it?" I would say, from what I heard, my kids were not happy that I was also helping the father save his daughter or their sister from the mother. But then again, they only heard from the mother, and I'm always the bad guy. The order. States, after all the testimony, so there wouldn't be a findings or anything else by the judge or a determination by the judge, she took the smart move. Also having appeared, Arlene Carella, through her attorney, having informed the court that she wishes to withdraw her petition, and with the consent of the court and the father's attorney on behalf of the father and the law guardian, it is now hereby, here's where the real kicker comes in, ordered. So in other words, she withdrew her petition. This is all agreed to. There are no findings. That the order to show cause and petition of Arlene Carella, petition Vera Jatuta, is hereby withdrawn. It goes farther. Ordered. All prior orders providing for visitation between the mother and the daughter are hereby vacated. Means she doesn't get the child on Sundays anymore. She has no visitation rights to the child. Can you imagine a mother not getting any visitation rights to the child? I can't. But this is what happened. And she agreed to it. Now, let's go forward a few years. About 4 or 5 years later, she files a petition. This was a Saratoga, but ended up in Schenectady County. Now, the judges in Saratoga County, I'm not on their hip parading because she's my ex. They didn't want to touch it, so that's how it ended up over in Schenectady. But 3 or 4 years later, she files a petition with the court in Albany, claiming that the father is refusing to allow her to see the child. And she takes a couple of the older court orders before this one and attaches them to the petition. Now, let me state, the petition that she files in Albany court is she has the same attorney that she had in this proceeding. So the attorney is well aware of everything, of what he's putting in there. So the father calls me up and he says, "What do I do?" He really doesn't want to spend any money. I said, "Look, you got the court order, the last one that terminated her parenting time?" He says, "Yeah." I said, "Take that to the court with you." So he gets up, he gets down there. He's got like a 9:30 appointment, 10 o'clock appointment. Neither her or her attorney show up. They have him sitting there Now, if a father's sitting there, mother is, and the father's not there on time, they go ahead with the proceeding and do whatever they're going to do and throw the father, whatever. Mothers don't show up. They wait until the mother shows up. Around 11:30, I guess, the mother still hadn't shown up. But here's the two interesting things. He walks into the court, into the family court there, sits down. He turns, all of a sudden this law guardian walks up to him and says, "I'm your daughter's law guardian. Why are you refusing?" Now, she has never contacted the child. She has never contacted him to see what's going on. She walks in there and says to the father, "Why are you refusing to allow your daughter to see her mother?" He goes, "What on earth are you talking about?" "Well, you're refusing and there's court orders and everything." He goes, "Wait a second." He pulls out this order that says she withdraws her petition. The law guardian reads it. She then reads this: "All prior orders of the court for visitation between the mother and the daughter are hereby vacated." There are no orders. He said she just kept flipping. Here the law guardian is flipping back and forth looking at the court order, can't believing it. Finally she just said, "Okay." They go into the courtroom. Now he brought extra copies with him, so he gave her one of the copies, so he still had one. He walks in there, first thing out of the judge's mouth: "Why are you refusing to allow your daughter to see her mother?" I can guarantee you, he doesn't say that to the mothers. Why are you refusing to allow the father to see his children? The law guardian speaks up and says, "Judge, you might want to take a look at this." He hands the bailiff a copy of the order. He says the judge sits there, starts reading it the same way, and keeps flipping the pages back and forth. Now the mother still hasn't shown up. The judge did order her petition thrown out, the violation, because there wasn't any, and he also ordered that she couldn't file in Albany County again. But this is what's going on with our court system. Why are they treating, why are the law guardians so upset when a mother doesn't see the child, but they're not upset when the father? And if you notice, and ask most fathers, they will tell you, when you walk into the courtroom, the mother, her attorney, and the law guardian are all sitting together. Or the law guardian will be sitting behind the mother. It's like the father has some type of disease that needs to be, whatever, away from them. But this is good. That's why we need open family court proceedings.